Assalamu alaikum. Today we have Nabeela Moola. Very warm welcome to you, Nabeela. We are joined by an individual who is an admitted attorney of the High Court of the Republic of South Africa. Nabeela is also the director of the law firm in Moola Incorporated in Gauteng. Thank you, Nabeela, for joining our channel. It's a pleasure to have you here.
Wa alaikum assalam. Shukran for having me.
Alhamdulillah. All right, so we are here to discuss the ICJ rulings. South Africa filed a lawsuit at the end of December in 2023 at the International Court of Justice, accusing Israel of genocide against the Palestinians, in particular in Gaza, and describing the apartheid, the occupation, as well as the blockade that has been imposed in Gaza. Now, the hearing took place over 2 days, on the 11th and the 12th of January. South Africa presented on the 11th and Israel presented on the 12th. The hearing took place in The Hague in the Netherlands, and the court has ordered Israel to take all measures to prevent genocidal acts, but not a ceasefire. So I'd like to unpack this further. The case at the ICJ, as well as the judgments issued by the International Court of Justice, what do they mean for the people of Palestine? What do they mean for Israel as well as the international community?
Okay, so first of all, a huge congratulations to South Africa. What a momentous win, not only for South Africa, who are, in my opinion, the true leaders and beacons of freedom, but to the Palestinian people whose plight has, for the first time in history, been recognized by the World Court. And now we acknowledge that no order is capable of compensating the Palestinians for the devastating loss that they've already suffered. But we are confident that this order is the first step towards their liberation, which Nelson Mandela encouraged us to fight for. Now, to get back to your question, let's unpack what that order says. So essentially it orders, and it's a final and binding order, that Israel must take all measures within its power to prevent the commission of a genocide. And this is extended to the military, which is the IOF. I like to call them the Israeli Offense Force. As well as to punish them for any incitement towards the genocide. But what are these genocidal acts? And if you look at the definition in Article 2 of the Convention, it refers to the killing, and I'm going to refer this solely to the Palestinian cause, is the killing of the Palestinians. It's causing of serious bodily and mental harm to the Palestinians, deliberately inflicting on the Palestinians conditions that are calculated to bring about their physical destruction, and imposing measures intended to prevent their births. Now, if you look at this in the context of the order, you will see that it's got the effect of effectively seizing Israel's aggression against the Palestinian people. And I know a lot of people, viewers and listeners, are concerned that the word ceasefire wasn't used, but the effect of the order has a same or similar, if not better effect. And I say this because if you look at the definition of what a ceasefire is, it's a temporary stoppage of war, temporary. And it must be by agreement between the parties. What this order is a final and binding order against Israel, against the IOF, and against any of its accomplices to immediately and permanently seize any acts of genocide as outlined in the Genocide Convention. And they have no right to appeal this order. So I understand the unhappiness, but we must also understand the true nature of what this order entails. And for the international community, this is huge because there are 153 states that are party to the Genocide Convention. This order now not only places an obligation on Israel to desist in their genocidal act, but also places an obligation on every single one of those 153 states to act independently and immediately to prevent the genocide of the Palestinian people and to ensure that those states themselves are not complicit in genocide by aiding and abetting Israel and its military in the genocide against the Palestinians. And this obligation goes so far as to state that states who are complicit must cease in funding Israeli military when their actions are, as the ICJ has stated, plausibly genocidal.
All right, Jazakallah, Nabeela. Thank you for the insight into the Genocide Convention. My second question is, how did the International Court of Justice arrive at the decisions to pass the judgment in the way that they did, given the case that South Africa brought and Israel's defense the very next day? I know you mentioned that the word ceasefire wasn't used, and there is this great distress amongst the community as well for that specific word being not used. What are your thoughts on that?
So South Africa presented a very meticulous and cogent factual legal argument. And in fact, this was wholly considered by the ICJ. If you listened to the judgment that was presented, they utilized the facts and statistics provided by South Africa in their application to eventually reach the order and the ruling that they did. Israel, on the other hand, didn't necessarily present a defense, and I'm very wary to call it a defense. In fact, what they did was they initially raised a technicality surrounding whether a dispute was declared by South Africa in a vain attempt, in my opinion, to have the application dismissed. But that aspect in itself was fully ventilated by the International Criminal Court of Justice, wherein they stated that South Africa issued public statements on various multilateral and bilateral settings expressing their views that Israel was acting in breach of the Genocide Convention. And Israel simply dismissed this as being unfounded and, in fact, morally repugnant. So based on that, the court found that that was sufficient to establish the existence of a dispute, which effectively dispelled Israel's claim that because there was no dispute and we were not invited by South Africa for a roundtable over coffee to discuss our acts, the court had no jurisdiction and authority to preside over it. And their remaining defense, if you want to call it that, is simply that they attributed blame to Hamas while cowering under the veil of them being Holocaust survivors.
Right. No, 100%. That is very much what I had realized as well after my analysis of the video recordings of today. So the question follows is, Israel also requested to throw out the case. And in your opinion, what was their intention for requesting this at the ICJ?
So up until the present minute, and it's not even the present hour, it's literally as we speak, Israel believes that they are not complicit in genocide or genocidal acts, and that they've been operating within the confines of international law. You've heard it time and time again from them, that they are the light of the nation, that they are the most moral army in the world, and they are ambassadors of never again. On their version, and on their version alone, they sought to convince the International Criminal Court of Justice that South Africa's application was nothing more than a blood libel and anti-Semitic, and that South Africa was quite simply operating as the legal arm to Hamas. Premised on this, along with the technicality raised regarding the existence of a dispute, which I previously mentioned, they requested a dismissal of South Africa's application, which in my view was wholly incompetent. And the rationale behind this request, in my opinion, was the damning effect the order would have against Israel and its reputation as being the most moral army in the world. And also the measures that would be taken by the international community against Israel in preventing the Zionist state from continuing to act with impunity.
Okay, thank you so much for that, Nabeela. So I believe it was around 2004, if I'm not mistaken, where the ICJ had ruled for Israel to stop the construction of the apartheid wall and dismantle it. Israel didn't abide by that order at all and by that ruling. What does this mean under international law? And do you think that Israel would abide by the current ICJ rulings that have favored South Africa's case, basically?
So the credibility of international law is always hung in the balance, especially when it comes to the Palestinian cause. And Netanyahu has unequivocally said that even the Hague was not going to stop them. And Israel's Minister of Security just a few minutes ago or hours ago published a post on social media following the ICJ ruling stating Hague schmeig. So it's clear that Israel has no respect for the rule of law. They have no intention to comply with the rule of law and has always effectively been a law unto themselves. So do I think they'll comply? No. And why? Because they don't believe they've done anything wrong and they have a legitimate right to self-defense.
Right. And we don't really expect the Western world to also follow through. Countries that have backed Israel and have supplied arms without question, without any intervention from their own constituencies, without getting approval from the government, like United States had done. So I don't think even in that matter we will be seeing much progress as well, because Israel does what it pleases, of course. Now, my final question to you is basically, where do we take it from here for the Palestinian community, especially in Gaza? What does it mean for them? And what does it mean for the international community at large, as well as international law?
So the United Nations Security Council will now be informed of the court order, and they will have to take measures to give effect to the order and effectively enforce the provisions of that order. The next trial, essentially, I mean, we've gotten past the first domino, and the next domino is essentially whether the permanent members at the United Nations Security Council will exercise their power to veto any of the United Nations efforts. And that really will be an indictment on Western morality. From an international perspective, as I previously stated, states who are party to the convention will have to adopt measures to prevent the genocide, as well as take action against those who are complicit in aiding and abetting the genocide. Thereafter, the trial will effectively proceed because, as you know, the ICJ has stated that there is plausibility of genocide being committed by Israel. And it's now South Africa's responsibility, and any state who chooses to support their case, to prove that Israel is in fact guilty of genocide and has acted in breach of the Genocide Convention. This can take years, and if history is any measure to go on, we'll look at the matter with Bosnia, where that started in 1993. It only effectively ended in 2007, so we were looking at a 13-year run there. And if we look at the case with Myanmar, and I must state that the provisional measures granted in the Myanmar matter was very similar to the measures granted by the ICJ in the Palestinian matter today. And that matter started in 2019 and is still running to present. So we've got a long road ahead of us, and that's really why one of the orders granted by the ICJ was the preservation of evidence, because that is ultimately what will be utilized in the trial proceedings to bring Israel to book.
Okay. Thank you, Nabeela, Jazakallah, for your time. I think there's still several things that basically need to be done to cause more pressure to Israel and bring an end to the Israeli brutality that we see every day, basically, on our screens, against Palestinians who are very much suffering every single day with the blockade, with no humanitarian aid, no food, no water, electricity. There's still a lot to be done. However, Nabeela, I do thank you once again for your time. It has been a very insightful discussion. We do hope to have you again.
Thank you so much for having me, and we wish freedom and victory to the Palestinians.
Inshallah, Ameen.